Welcome once again to Lehto's Law. Here's Steve Lehto.
You'll have to forgive me. I was up kind of late last night. There was a football game on. And David sent me this note. It said, Steve, check out this story from Wyoming. WyomingNews.com ran it. Sophia Sarek wrote it. Wyoming Supreme Court rules that police can search based on nonverbal gestures and believed authority to consent. So in other words, they're going to come in and they want to search someplace. They need permission to do it. If they think they've got permission based on a nonverbal gesture, and they have a good faith belief that they've got the right to do it, they can do it. And if someone comes by later and says, I never gave you permission, the court will say, well, they thought they had permission and they had good reason to think that. So this, as you can imagine, could lead to trouble. The Wyoming Supreme Court ruled that law enforcement officers can legally search an individual's home, papers, and effects as long as they reasonably believe they have consent, verbal or nonverbal, from a person with authority. Because that's another question, is suppose they come up, knock on the door of a house, someone answered, they go, can we search? Yes. What if that person is just a visitor? What if they're a trespasser? So a man entered a conditional guilty plea to possession of drugs. The no contest plea reserved his right to appeal certain issues in the case. On appeal, he argued that the Laramie County District Court made a mistake when it denied his motion to suppress evidence that law enforcement had obtained after they entered his apartment without a warrant and without his consent. Physical entry into a person's home is the chief evil against which the wording of the Fourth Amendment is directed, said the Supreme Court in its opinion. The Cheyenne Police Department officers were dispatched to the apartment of the man in March of 2022 for a report of domestic violence. When the officers got there, they found the alleged victim sitting on the stairs directly outside of the apartment. An officer asked her what happened, and she motioned to an injury on her face near her eye. So apparently she didn't answer. She just pointed. So the ruling states that the man, the defendant, was allegedly intoxicated and kept hitting her. The woman opened up the apartment door and called to him. She stepped inside and while holding the door open said, "Here you go. The police are here for you." Now, the man denied any wrongdoing, but later admitted they had had an argument. He had blood on his nose, but declined to tell officers his side of what happened. He was ultimately arrested and transported to Laramie County Detention Center, where officers found approximately 39 grams of suspected drugs and approximately 26 grams of another suspected drug, and that would be on his person. The man was charged with domestic battery, strangulation of a household member, and 2 counts of possession of a controlled substance. He filed a motion to suppress any evidence that flowed from the search and seizure, arguing the officers violated the Fourth Amendment by entering his apartment without his consent, without a warrant, and without exigent circumstances. Exigent circumstances is a reference to the fact that sometimes the police have got to do something in the case of an emergency. And if they do it in the case of an emergency or these certain exigent circumstances, they might be able to say, we didn't get a warrant because of these. Very unusual. But the Laramie County District Court denied his motion. In the end, he pleaded guilty to 1 count of possession in exchange for a reduced sentence, dismissal of the other charges, but he retained the right to appeal this one issue. So he appealed that to Wyoming Supreme Court. He argued that the district court made an error when it found that officers had a reasonable belief that the woman had the authority to consent to a warrantless entry. So they're saying when she opened the door and said, hey, these guys, cops are here for you, that was them being told, yeah, come on in, search the place. The state's highest court concluded the woman had the believed authority to consent to the officer's entry, and she implied consent to that entry based on her nonverbal gestures. According to the Supreme Court, no Fourth Amendment violation occurs when law enforcement reasonably believes that a person who consents to a warrantless search has authority over the place or thing being searched. The question is whether the facts available to the officers at the time they entered the apartment would warrant a man of reasonable caution to believe that that woman had apparent authority over the apartment and consented to that entry. A warrantless search is legal if the answer to that is yes. In this case, the woman called from that location, was at the residence, had come from inside and freely re-entered the apartment. It was reasonable to believe that she had authority over the home, according to the court. The man also argued the woman never consented to the officer's entry into the apartment. But the Wyoming Supreme Court ruled that although consent must be clear, it does not need to be verbal. And her actions would lead a reasonable officer to believe that she consented to entry of Alexander's apartment. The woman, instead of verbally responding, grabbed the apartment doorknob, opened the door, stepped in, and confronted the man. And while holding the door open, she said, "Police are here for you." And to me, that still doesn't sound like she's inviting them in. The police are here for you. But that's where we are. And so this is always a dangerous thing to do when they create new precedent like this and spell it out, because what happens now is, prior to this, it would have been a big gray area. And there's two things they're saying here are coming down from this case. One is that if they simply believe that you are in charge of the property, then you grant them permission and then go in. So what this does mean is a smart officer now won't ask, "Is this your place?" They'll just say, "Can I come in?" If you say yes, I'm assuming you said yes because you had the right to say no. But if it's not your place, see, and that's one of the problems. The other problem is that they say it can be search based on nonverbal gestures. Nonverbal gestures. Now, I got news for you. Some people are very, very expressive with nonverbal gestures. I also know other people who are very, very poker-faced, or they got a rich, the resting unsmiling face. And I have had people come up to me before and say, "Are you pissed off?" "No, why?" "Oh, I'm sorry, you look like you're pissed off." Sometimes my face relaxes into an expression that makes me look pissed off, apparently. I try not to do it on camera, okay? But the point is that interpreting nonverbal gestures, nonverbal cues now is something that the police can say. We walked up there, asked if we can search, and the guy shrugged his shoulders. So I assume that meant, "I don't care." And so we searched. And the guy could say, "No, I shrugged my shoulders because I'm like, what? Why are you asking me that? It's not my place." Okay? So there's two issues that arise here. And unfortunately, and I can tell you this from taking criminal procedure in law school, you will read cases and series of cases on a particular issue, such as searches. And you'll discover that a case will come down and make a ruling. And another case will come down, and it's weird. You'd think, well, that last ruling should have settled this issue. No. And these new facts keep popping up. And so you're going to get some facts like that, where the police came onto a scene and they saw somebody. "Can we search the place?" Person said yes. Later we found out that person was just a weirdo who wandered in to see what was happening because they saw police cars. And so that's a problem when you say that, well, if we believed we have the authority to consent, but you don't put on us. And so you might say, "But Steve, how would you fix this if you were a court?" If I was the court making this ruling, I would say that they have to have a reasonable basis to believe that. And if they're doing it off of nonverbal gestures, they need to clarify it. But the real point here is they don't want to clarify it. Like I said, they can walk up to somebody now and go, "Is it okay if we search this place?" Okay, now they can search because they interpreted this to mean yes, and they assumed that person had authority. That's the problem. So anytime, especially you'll know that the court did point out physical entry into a person's home is the chief evil against which the wording of the Fourth Amendment is directed. That's the number one thing people want to feel secure is in their home, okay? And so the woman, when they encountered her, was outside. They say, well, she stood up and she opened the door. Okay, the door was unlocked. Does that prove that she had authority to consent to the search of that apartment? No, of course not. But except now, yes, it does. See, that's and that's the problem here. So, David, thanks for sending this. But from WyomingNews.com, and again, this is happening in Wyoming. And I always have to explain this, that when a state court interprets the Constitution a certain way, it becomes binding precedent in that state. So here's a Wyoming Supreme Court case that theoretically now is good law across the state of Wyoming. If you're in a nearby state or another state and your court hasn't ruled on this, can you count on this or will this hurt you? And the answer is it could kind of, Because when you're making an argument before a court on a novel concept that's never been before that court before, so let's suppose that you're in Ohio and you have this exact same set of facts, but your court's never ruled on it. You could then say, Your Honor, we know this court has never ruled on this before. However, there is a case from our learned brethren and sistren in Wyoming where they've ruled on this, and we want you to rule this way. Or, if you're going the other direction, you'd say, case came down in Wyoming that is completely wrong. Let me explain to you why. You should not follow that or imitate that. And so it's not binding precedent, but it can be what they call persuasive. I can tell you that some fields of law, like the Uniform Commercial Code, it's not uncommon that if you have a section of the UCC, Section 2, regarding sales that's never been interpreted in your state, you find how it's been interpreted in other states near you. And if you find cases that go your way, you argue them all day long. And the UCC being adopted by all the states, with most of them adopting it verbatim, then how it gets interpreted in one state often is how it gets interpreted in another, eventually. So right now, that's what's happening in Wyoming. Sophia Sarek wrote that for the Casper Star Tribune, and it got published on wyomingnews.com. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Meow means woof in cat.